Good afternoon, everyone, and welcome to today's webinar. My name is Sandra Vidrio, and on behalf of the Fresno Area Hispanic Foundation, we would like to say thank you for joining us for today's free legal workshop in partnership with Berkeley New Business Community Law Clinic. Before getting started, I would like to show you a quick tutorial on using the Zoom tools that appear on your screen. Throughout the presentation, to submit your questions, please select the chat icon that appears on your screen if you're using a computer. And if you are using a mobile device, you will need to select the option where it says More and then select the chat option. For today's webinar, we are joined by the team at Lingüística who will be doing live interpretation from English to Spanish. Estoy contenta de anunciar que en el seminario web de hoy tenemos la opción de que se sea traducido de inglés a español. Y para acceder a esta herramienta, por favor de seleccionar la opción de interpretación o more que aparece en su pantalla y después va a hacer clic en la opción de español. Y asegúrese de que silencie el audio original. I would like to recognize the following sponsors that allow our organization to provide these weekly webinars to our business community. Thank you to Bank of America, Bank of the West, Chevron, Federal Home Loan Bank of San Francisco, Donna G. Sales, Wells Fargo, Tri-Counties Bank, and JP Morgan Chase & Co., and Union Bank for your support. Before getting started, and this is the agenda for today's presentation. So we will be joined by the team at New Business Community Law Clinic, and after we will be having a live Q&A session. Before getting started, I would like to quickly share about the organization, Fresno Area Hispanic Foundation. We're a nonprofit organization here in the Central Valley with the mission to promote education and self-sufficiency by fostering entrepreneurship. And at this time, our team is working in providing the following core programs to our community on a remote timeline, and that includes our virtual technical assistance, our weekly webinars, and our microloan program, and as well as communicating of other relief programs that have been made available to our small business community. In addition, we have our newest program, which is Womanpreneur and Latinapreneur, designed to help women entrepreneurs grow their business using online marketing tools and develop a strategic marketing plan. To learn more about our program, please call us at 559-222-8705, or you can also follow us on our social media platforms at Fresno AHF to keep up to date with all of our upcoming events and webinars. And so during now this transition, I would like to present our presenter for today. And so let me go ahead and make them a co-host. And as mentioned, this partnership that we have with New Business Community Law Clinic has been in existence since 2019, and this is a legal resource provided to help and assist those startup businesses here in the Central Valley, as well as perhaps you've been in business for a year and you have questions and you're needing legal, and so we have the team at Berkeley Law that is here to help us out. So thank you so much for this great partnership, and of course our well-known Third Friday weekly workshops. Desiree, would you be able to share your screen, or would you like me to?
Yeah, and then, oh, I lost it. Did you click? Okay, let me please share screen. After me, Mia is going to be presenting, and then Sarah.
Okay.
Let me see the share screen. I'm sharing via PDF, not a PowerPoint, so that I don't lose things in case the web kicks me off a little bit. So can y'all see my screen?
Yes, perfect.
All right. So just as always, we just want to give the little legal disclaimer that the following is a general presentation of the law. You should always consult a lawyer to obtain an evaluation of your specific situation, and that's what we're here for. We're happy to talk with you one-on-one today or during the week when we have our office hours. We could give you more information on that on our website, and Sandra has it as well. You could also sign up every third Friday. We have the office hours before and after our presentation. And just another little agenda within our other agenda. We'll be talking about protecting your presence online. Now that everyone is, or a lot of folks are working online, we wanted to focus on things that will be important to y'all now during this COVID pandemic, the things you should be focusing on how to protect your business. So although we're touching on trademarks, copyrights, and IP by contract, there's other types of IP like trade secrets. And patent law is a quite extensive area of intellectual property. And a lot of folks don't necessarily need it, but it's the one that people hear about a lot. And they're like, hey, I want a patent, you know? So one of our senior students will be talking about that later on, and it's towards the end of the presentation. So do hold your questions. We'll get to them at the end. And then right before patents, we're going to be talking about the Americans with Disabilities Act and how it applies to online. You might think that, hey, if you have a small business, you're not a big player, so you're not needing to follow those rules, and it's not true. And that could be an easy $10,000 to $15,000 mistake, and it's cheaper to fix it beforehand. So the purpose of IP protection, a lot of people say, well, hey, I have things, I want my business to grow, so I just want, you know, the rules that are going to protect me, you know, what am I going to do so that I can grow? Like the government is here for me, right? Well, the purpose is to encourage artists and inventors to create and share their works, their inventions, their creations. And yeah, it is to enable commercialization on one end, but it's mostly to prevent like customer confusion, like within trademarks, so that customers and society in general are protected against bad products, and they could, like, folks can really stand behind their products within the trademark aspect. So although there is the aspect of commercialization and making money with the things that you've created, the law is more generally applied so that it could help society at large, right? So now I will pass it over to Mia to talk about trademarks. Let's see.
Hi everyone, I'm a student in the New Business Community Law Clinic, as Desiree said, and I'm going to be going over trademarks and copyright today. So as I go through this, I'm going to be talking about what your rights are as a trademark or copyright holder and kind of how you get those and what it allows you to, what it means for you to own those rights. And then I'm going to talk about what it means that you can prevent other people from using your own intellectual property. And then I'm going to talk about, just because this presentation is specific to online, and as we all know, online, you know, transcends the whole world. So I'm going to talk a little bit about the other places, even beyond the US, where your trademark and copyrights might continue to be protected. So I'm going to start with trademark, and a trademark is anytime you see like that little TM sign next to like the title of a business or something like that. So as you can see here, that would cover slogans, names, logos, colors, scents, and sound. So it's like really these kind of like identifying monikers for your business. And so in order to get protection in your state or under common law jurisdiction, you just automatically get protection once you say like, okay, my business is named whatever. But for federal law, you need to register your copyright. So that's what we're going to talk about now. Next, please. Thank you. So there's different types of trademarks. Obviously, you can see here some of them are really basic. If you can say, well, my company is called Carpet Cleaning Company, and then the more kind of detailed and graphic you can get, the trademark becomes more distinctive. And so the more distinctive your trademark is, the easier it's going to be to trademark, because as Desiree said, you know, the point of these is really to help out the consumer. So the more distinctive of a mark you have, the easier it's going to be for one consumer to know they're talking about your business and not some other business here. So you can see we have like American Airlines, a little bit more generic, and something like this apple, you know, it's a random fruit that stands for something that we all know so well now. So before you go ahead and try to make your own trademark, you're going to want to check out the uspto.gov to make sure that somebody doesn't already have your trademark, because the whole point is to be unique. So you don't want to have something someone else already has. And next, please. Oh, could we go to the next slide?
Mia, I think you're muted.
There we go. Does
There
that
we go.
work? Okay,
Yeah.
great.
Perfect.
Thank you. So we're going to talk briefly about what it is that you need to do to get a trademark right. So the first thing you have to do is use it in commerce. So in order for the trademark to be meaningful, you can hear me, is that right?
Yes.
Okay. In order for the mark to be meaningful, it has to be used. So, if you just like make a company and you keep it inside your house and no one ever knows about it, it's not going to be a helpful trademark. So you have to be using it in commerce. If you don't use it in commerce, oops, our slides just disappeared. If you don't use it in commerce, it will be protected, in your local area. But in order to have that federal protection, like we said, you need to have gotten it registered. And then the state ones to register are much cheaper, I guess a little cheaper. And then for the federal registration, that would be about $325 to cover your name and your logo. Next. And then these are, this is kind of how your trademark is going to work once you have it. As long as you maintain that trademark, it's going to belong to you. So you need to keep maintaining it, keep using it in commerce, and then it will continue to be protected. And then the U.S. has a treaty with some other countries, the Madrid Protocol, and so all the countries that belong to that treaty will also enforce your trademark worldwide. So I'm going to jump now to copyrights. That will be the next slide. Thank you so much. So copyrights are a little bit different from trademark. A trademark is going to talk about kind of like the name of your business or your business slogan or logo or slogan, and copyright is going to be more for something of a work that you created. So like you can see here, it could be art, it could be a book, it could be movies, software. One important thing about copyright is it has to be kind of specific. So you can't protect facts or ideas. You can't say, well, the sky is blue and I copyrighted that. It has to be something you came up with a little bit more. And then we're going to talk a little later as well against the fair use doctrine. So no matter even if you have a valid copyright, there's still going to be some times when other people can kind of use parts of your intellectual property for their own adaptations or purposes. So if you are the copyright holder, next slide, please. Thanks. These are the things that you're going to be able to do. You can reproduce it. You can develop a derivative work. So that would mean like you could have your, artwork, and then maybe you could take your sculpture that was made out of wax and make it out of a different material, or your artwork that was blue and you could make it red. So that's what a derivative work would be. You can distribute it, so that means you can share it out with other people. You can do a performance of it, or you can do a public display of the work. And that means, you can see at the top here, it says exclusive right, and that means that these are all things that are your rights to do as the copyright holder, and these are things that if you hold the copyright, other people should not be doing. So if other people are doing those, then you might be able to say, that they are unfairly appropriating your copyright. So just like with trademark, next we're going to talk a little bit about what you need to do to get a copyright protection. So once you make a work, you automatically have a copyright on this work. So I'll give you an example from my life. I was a music major in college and I wrote a piece. So once that piece is in writing and it's performed, the copyright is already there. So that's just automatic. What is really good to do, however, is to register your copyright with the U.S. Copyright Office. It's not very expensive. So here you can see it's $45. And once you do that, it helps you with enforcement. So like I said in the previous slide, if you think somebody is like taking your copyrighted material unfairly, if your copyright is registered, it's going to be easier to protect. And that copyright, unlike the unlike the trademark that we just talked about, with the copyright, it's going to, oops, can we get the next slide, please? Thank you. So with the copyright, your copyright is only going to last until the end of your lifetime plus 7 years. And the reason for that is coming back to something Des said early on, which is that, these laws are really intended to promote creation and promote innovation, but it's for the purposes of like the greater good. And so we want you, once you have your copyright and it's kind of like, you got your worth out of it, and then you 70 years passed after you died. Now we want it to become something that everybody can use. And so obviously that's not always true. You know, with Disney, we see these Disney movies that get copyright and it keeps getting renewed like forever. But in general, the copyright is just going to last until your lifetime plus 70 years, assuming you're the individual creator. And then as you can see here, if it's work for hire, it's going to be a little different. So like if you made a work while you were being employed by like the university, say, and then the work belonged to them, the rules are going to be a little different because it doesn't have to do with like a specific individual. And then as we said with trademark, there's an international convention that means that all the countries who are party to this Berne Convention, this is a treaty that means those countries would also recognize your copyright. Okay, so we're gonna go now, oops, sorry. Next slide, please. Yeah, so this is specific to, you know, the modern times and the new internet world that we live in. And so this is specific to, as you can see here, tech devices or services that try to get around your copyright material. So if you see something that you think is infringing on your copyright, you know, maybe somebody took an artwork that you made and they posted it on Instagram or whatever, that would be a violation of this law, which is just recognizing that it's a lot easier to kind of share things nowadays, even though the person sharing them might not actually be the owner. So if you think that's happening, as Des said at the beginning, definitely a good idea to check with a lawyer. But some of the early steps you can take are to send a cease and desist letter. So you would just, you know, email the person who's doing your copyright violation saying you need to stop using my artwork in your, you know, messages, or you can contact whoever is doing it. So this is just to help protect your copyright in an online environment. And then the last thing we're going to talk about with copyright is that, like I said at the very beginning, you can actually, even if you have a copyright, other people can use it for a few things. So that could, some examples here are criticism, comment, research, reporting, scholarship. So for example, you know, if you see images on this slide, maybe those are things that are copyrighted, but this is an educational setting, and so we can share those. You can always do a parody of a work. You know, if something is copyrighted, it can be featured in the news even though it has a copyright. So just to recap, we have talked about trademark and we've talked about copyright, and both of these things, if you get you get some sort of right just for being the creator, and it's much easier to enforce your rights if you register either your trademark or your copyright, especially with the federal government, but also even with state and local governments. And when you protect your rights, it means that you have certain things that you can do with your materials, and you're allowed to tell other people that they can't use your materials because you're the copyright or the trademark owner. So we're going to talk just about one last thing on trademark and copyright.
One thing, Mia.
Oh, yeah.
So you did perfectly describing the Digital Millennium Copyright Act, the DMCA takedowns. I just wanted to reiterate that you don't need the copyright protection to be filed in order for you to do these. And I have that little Instagram screenshot there because Facebook, Instagram, and Google are really good at just taking down images. They have their own little systems that you could just go in to make the complaint, and then you can just give your website or something that just proves that you were the first one to post it. And, you know, with the internet, it basically has timestamps on everything already. So instead of going straight to the person who's violating your stuff, because a lot of the times they know that they're copying you and they don't care. So you can just have it taken down without them even knowing. It is friendly to just go to them first, but I just wanted to make clear that you don't need to do the filings in order to do this. You need to do the copyright filing in court before you sue regularly, but that's all.
Yeah, thank you. Thanks so much for clarifying that. So on that topic, going over back to IP by contract, that's a time when you're saying that you actually you're giving a shared right to your copyright to say that other people can also use it. So these are some types of copyright contracts that you can have. So Creative Commons is like you can put your something online and say, you know, I'm going to put this online and whoever wants to can use it. As it says here, there might be like really specific conditions. So it might say I'm going to put my stuff online and you can share it like for one purpose, but you can't share it for another purpose. So like maybe you can share it to tell all your friends about this cool graphic, but you can't share it to like make your own t-shirts and sell them. But you're going to kind of give a subset of rights to other people to let them use your work. Non-commercial uses, so that's like if you put something online and you say, you know, here's what our website looks like, and it's fine if you share your website in front of our class or our presentation or whatever. And then a license or assignment of IP rights would be more kind of individualized. It would be like, I'm the rights holder for something, but I'm going to say, you know, I'm going to let Des use it because she's going to adapt a movie of my book that's going to be really cool. And so I'm going to give like a specific kind of agreement between the different people involved to say that they can use the copyright for that. So that's just a really quick overview of trademark and copyright and just some of the reasons why we have these IP protections in place. Hopefully that was helpful for everyone, and I'm going to turn it over now to Sarah.
Oh, and one last thing on the website terms of use, or when you have like the terms of service, obviously that's a little contract that you basically are signing without signing when you are using a website. But the more important part is if you see a contract like that you like, some terms of service, and you want to adopt that language, you can. That is not copyrighted language, because if you think about it, if it could be copyrighted, then somebody could have like the best terms and then nobody else will be able to use them. So yeah, if you have a competitor business that's really big, it's cool to go look at their terms and then massage it into something that's true and right for you. But yeah, continue. Oh, actually, I will be talking about this one. So again, with the Americans with Disabilities Act, there's stuff for an online presence to worry about too. Back in the day, 2006, Target was sued by the National Federation of the Blind, and they were saying Target's argument was that a website is not a place of public accommodation. That's what that PPA stands for, because usually a place of public accommodation is like when you're going into a store and they need to make sure that the railings and the door frame is wide enough so that a wheelchair could go through. There should be a ramp and that type of accessibility. So Target was saying, hey, we're not a place of public accommodation, so the ADA rules don't apply. And the court said, no, you have to. And not only that, like they had issues with their photographs just being put on the website and not describing what was on there. So let's say they had a shirt for sale or a bottle of soap. They could have easily put Dove soap something, you know, and t-shirt by whatever. And they could just describe the coloring and what the image looks like. And they wouldn't have had to go through this big lawsuit and had to pay money for the National Federation of the Blind. And that's something that applies to you in the sense of your Facebook, website, and Instagram posts. As you may be aware, Instagram recently in the last like half year has made it so that you can describe your images by using an alt text. So that's an alternative text. And that's just basically an alternative thing that comes up if your image does not show up on the website, or if somebody who is blind is reading or viewing your website through a screen reader. And it's also great for folks because if I'm trying to rank heavily on a certain product that I'm selling, the more descriptions I give within my images, so long as it's factual, is gonna weigh me heavier on the Google rankings or any like Bing rankings. So any search engines are gonna be crawling your website looking for the matching words when people are searching things. So the more alternative text language that you're putting on your images, the better you're doing. Is just free search engine optimization. So anyway, in 2012, the National Association of Deaf sued Netflix. And Netflix was like, hey, we don't even have real in-person stores. And that's how they were trying to be different from Target. They were like, Target, they have actual stores. So sure, they should follow the ADA in person and online. And then the courts decided that no, even though Netflix did not have a physical location, they also had to follow these rules. So even if you're a service-based business, if you're a consultant, your website should be following this. And there's not like super official guidelines of what to do, except for there's this WCAG 2.0, and there's different categories. AA is the middle category of what to follow. It'll tell you to do the alt text, to do things like good contrast between like the colors of your font and the background, you know, just so that it's readable. And the point is just to make sure that things are perceivable, operable, understandable, and robust. So you have to pour your heart into it. Perceivable is just so that you can see it. Operable is just so that if people are doing it through sound devices or visually impaired folks who are using screen readers, you know, the alt text and stuff are working for them. Understandable, I think it's also like that with the clarity. And robust is so that it can be used on different websites. So like if I open up a Safari or a Firefox and different types of browsers. Yeah, so you can continue. I think the next thing is advertising and marketing, and Sarah, take it.
Hi everyone, like Mia, I am a student at Berkeley Law and a member of the New Business Community Law Clinic, and I'll be covering a few slides on advertising and marketing for your business, particularly your online version of your business, and then I'll do a very, very quick overview of patents. So to start, advertising is one of the many possible marketing activities and perhaps the most ubiquitous. It may not surprise you at this point that the average adult in the US is exposed to more than 5,000 ads a day. I just watched The Social Dilemma last night on Netflix, and it's a little uncomfortable knowing how much ads are targeted at us and how much we see each day. But because it's so ubiquitous, there's a large body of law around it to regulate these ads. So the Federal Trade Commission, or the FTC, is sort of the primary body that's responsible for regulating advertisements, but the Food and Drug Administration, of course, regulates food and drug advertising in particular. So, is this an ad? You have here a picture of J.Lo who's doing a Throwback Thursday to her birthday party. But if you take a closer look, you notice that the bottles of vodka are very strategically positioned so that you can see their labels. And then in the description section, she's tagging and hashtagging this particular vodka company. So it looks very covert, but actually she's providing an advertisement for this vodka company without saying that she is. There are some advertising claims that are under larger scrutiny from regulators than others. Kind of first and foremost, what you need to keep in mind is that there's a lot of regulation around ads that make claims about health or safety. For example, a sunscreen that says, this will reduce your risk of getting skin cancer by 50%, or this water filter will remove all the harmful chemicals from your water, or this kind of food will reduce your chance of getting diabetes. Because people may be choosing those products because of health conditions that they have, or in general are interacting with them in ways that could have consequences to their health and safety, these are very strongly regulated. Also regulated are claims about things that consumers can't really evaluate for themselves. It's very easy to be deceptive if consumers don't have a way to check on you and see if what you're saying is true. So for example, imagine you buy a refrigerator that says, on a yearly basis, this fridge will reduce your energy costs by 25%. At the end of the year, you might see a change in your energy costs, but you have no way of knowing whether or not that was due to the fridge or not. Or a gasoline that says, this will reduce your engine wear. Unless you're a mechanic and can do a research study, it's hard for you to know whether that claim is actually true. So those claims are more strongly regulated because it's easier for companies to use them to deceive consumers. On the flip side, there are claims that are a little bit subjective or something that consumers can easily judge for themselves. So you'll see on a lot of food products, great flavor, amazing taste. That's something that a consumer, upon eating the food for the first time, can see, do I agree with this or not? And it's easily checkable. So those receive a little less attention from regulators. Okay. Thank you. you have to be careful when it comes to misleading ads. Ads are not supposed to mislead customers. If you have an ad and then you need to make some kind of a disclaimer or disclosure that sheds light on what the ad is actually saying, that disclaimer or disclosure needs to be clear and conspicuous. The consumer shouldn't have to click through 3 different sites on your website in order to get like, oh, here's this fine print of this advertisement that doesn't actually mean what it is. It should be up front and center. In addition, if you're making a claim, you need to have evidence to support your claim. So if you're a company that says, this food will reduce the risk of your diabetes, you need to be prepared if tomorrow an FTC regulator comes and knocks on your door, you have to be able to present the paperwork that says, yes, this is true. And just note that this kind of standard of truthfulness applies with advertising claims about sale prices, so saying that something's on sale if it actually isn't, which I'm sure that we've all been suspicious of stores doing, and just generally the products that are on sale as well. If you have spent any time on Instagram and follow any celebrities, you see this quite often, celebrity figures endorsing certain products. For example, Kim Kardashian's endorsing a medicine that helps with her morning sickness. There are a few things to note if this is a marketing strategy that you're interested in using. The endorsements have to reflect the honest opinion of the person who's sponsoring it. So it has to be true that Kim Kardashian actually believes what she is saying on her Instagram post, although note this is kind of hard to check and it can be subjective, but it's still something to be conscious of. In addition, that medicine company can't use Kim Kardashian to make a claim that they themselves couldn't do, so that she would have to abide by the same rules if she's has an informal endorsement relationship with that company. In addition, any affiliation between the person who's doing the endorsing and the company should be disclosed, because that does affect the credibility of that person and is valuable information for consumers to know. So you can't be secretive and do under the table payments to people to endorse your products. You need to be upfront about it.
And on that note, a lot of folks on Instagram like to do hashtag SP to be like, oh, that stands for sponsored. It doesn't. The FTC doesn't like that. And it has to say hashtag ad. And also folks like to use hashtag ambassador. You're not a hashtag ambassador. That like you are an advertiser. So like more and more bloggers are getting these claims from the FTC, like, you know, so it's not as regulated as it could be. But someone did ask in the comments, how does this work on Facebook or Instagram? So yeah, the FTC is looking on there. There was one time that 30 bloggers were instructed by, I think it was Macy's, to post about a certain dress on a Monday, like at the start of the week, and they all nonchalantly just posted about this dress, and it was the same exact dress, and 30 bloggers posted about it, and only 5 or so of them actually put that it was a sponsored post, and the FCC climbed on them, but there's just hasn't been any like heavy regulation in the realm of sanctions yet. But yeah, continue, Sarah. You'll talk about sanctions next.
Let's see. Next slide. Oh, we have some examples first. So here again, you can see some examples of deceptive practices. So this looks maybe like a, you know, normal picture that any of us would have on our own private jets, just eating our food.
And it becomes kind of risky here too, because I don't know if this is a chicken thing, but they're using these Hermes bags. One is like a $50,000, one is like $150,000 bag, and Hermes wouldn't really have such a licensing or affiliation of sorts with a food place. So it goes again to Sarah's other point of you can only do what the brand owner can do.
Right. Yeah, definitely. And you can see that it's very conspicuous and obvious where they've gotten their food from. It's very well positioned so that you can see the labels on top. And this is obviously an ad, but if you're just scrolling through Instagram or Facebook, you might miss that and kind of just subconsciously be advertised to. But the FTC wants that to be disclosed that it is an ad. Another example again, this is someone posting their bracelets and they're giving credit to the maker of it. However, this is very likely an ad, not something they just decided to do on their own, and it's not clear from the comment or the picture that this is an advertisement that's likely been sponsored by this.
Yeah, and this one was Sofia Vergara when she was on Modern Family, and then she's saying on set, and it's like, hey, is it Sofia Vergara the person, or is it the Modern Family actress? Like, who did they get to sponsor it? And that was like one of the sticking points for the FTC on this one.
And then another example of Victoria Beckham, who's marketing a product, but it's not clear that it's actually an advertisement. Although it's an odd picture just to kind of put up by yourself for your own fancy.
But I thought this one was a little harsh. Like, if that really is her friend and she just wants to promote her friend, like we could usually do, it's like, hey, it gets sticky there. Like, when do they draw the line? Like, she's so popular that she now just can't be friendly. But she got in trouble for this one.
All right. The reason that we're going over this is that there are sanctions for violating advertising rules, and likely as social media law develops, I imagine the sanctions will increase for kind of those deceptive advertising practices as well. If the Federal Trade Commission or the FDA determines that an advertisement is misleading, they can impose sanctions. Examples of past sanctions are cease and desist orders, meaning that you have to stop using your advertising, which can net you a loss of your marketing money that you've already used. Civil sanctions, which are basically fines, and they can be pretty hefty, ranging from thousands to millions of dollars. And then lastly, corrective advertising or disclosures or other kinds of informational resources. So you might have to do another campaign to correct the information from your previous campaign, which of course costs money. So here we have an example of Ocean Spray cranberry juice. You may have seen their advertisements on TV. They had to spend 25% of their advertising judgments to correct ads where they had said that certain juices didn't have artificial flavors when in fact they did.
And their sanctions were 5.4 million, aside from having to spend 25% of their budget on the fixes. Nice.
And then another example for Skechers. So they had this line of shoes called body toning shoes, and they were supposed to like help you tone your muscles. But what they actually did was just make your feet very unstable, so that people had injuries, they fell, they had muscular problems. It was actually really bad for people's health. So they had to, in a class action suit, pay $40 million to the people who bought those shoes and were affected by them. And then kind of lastly, on the point of advertising, something you need to be careful with is comparative advertising or advertising that calls out your competition. So Coca-Cola and Pepsi sometimes have comparative advertising, as do Microsoft and Apple. But they need to be really careful if you're making a claim either directly or indirectly that your product is superior to that other product, because that opens you up. The other company can come in and say, hey, this advertising was misleading and it hurt my profits. So they can come after you for monetary damages. And they can also call up the regulators and have them sanction you as well. Switching gears here, we just have one quick slide on patents. As Des said, patents are something that most people at least know by name, and it's something that comes up for a lot of new businesses in terms of, do I need it, do I not? It's important perhaps to say up front that patent is one of the more intensive processes to get one, and it can oftentimes cost thousands of dollars in legal fees in terms of hiring a patent attorney and going through kind of the iterative process. What a patent does, kind of at the most general level, it protects a unique invention. So it's an invention that's new, it's never been on the market before, and it's not something that's been filed in the patent office before. It has to be useful, it needs to have a function, something that someone can use, and it needs to be non-obvious. So it's not something where you can be like, oh, like anyone could have thought of that. That's easy. It needs to be something that's really like a stroke of creativity. if you do get a patent and you go through that kind of long process, what it does, it allows you to exclusively make, use, and sell the invention and exclude other people from doing so for a set amount of time, between 14 and 20 years. In exchange, however, through the patent process, you have to disclose all the details about your invention or process. So it's something that after that time, then anyone can use. And it's the idea of striking a balance between wanting people to innovate so that they can gain from that innovation, but also spreading that innovation throughout society. So that's why we have that shorter time limit. Again, if you're interested or think that a patent is something that could be right for you, that's something to discuss in office hours or with an attorney, because it is quite a process of communicating with the patent office and revising and kind of having the right language. So that's something that would require a little bit further attention later on. Okay. Great, I'll hand it off to Des.
Questions, anyone? Check our chat. I think Mia and Sarah did a great job, and so everyone is now well versed in trademarks, copyrights, IP by contract, advertising and marketing, ADA.
Yes, thank you so much for today's presentation. And I want to encourage our participants that are joining us, whether it's through Zoom or through our Facebook Live, to please send us your questions. This is a perfect opportunity. We have 3 wonderful presenters that are ready to answer any questions pertaining to the topics that were presented today. And so we have our first question, and so I'll be translating it here. So the question is, how long is the process for a patent to be accepted? So what's the estimate, I guess more like what's the step-by-step process on how a patent is?
Yeah, it's very long. I know the initial searches itself is going to be like, it could be a year and a half. It's not unnatural for it to be like that. That's why you see a lot of things like with patent pending and such, like once you start the application. But remember that once you start that application, you start releasing the information. And let's say like generally, like a design patent is less time. But let's say I created the Roomba. I was iRobot and I created that little vacuum, you know? If I would have put the information out there, or if I put it in an article and write about it, so long as I'm giving some information about it, that's when the time starts, the clock. So even the searching time period could be a year and a half. By the time you finally get your patent, it could be 3 years later. So you really only have like 17 years to really get as much money as you can out of it. Because then, as you saw, after the 20-year time period ended with Roomba, a lot of people just went out there and started making their own. I think actually they were smart right before it went into the open, into the area where anyone could use it. They started licensing it out to folks, which they still cannot get too much money for it because it was just about to be open in a year. But then those people could, you know, try to up level off of that. I'm doing a lot of lawyery circling just to not answer the question.
Yeah.
It could take a really long time. Even a trademark is easier. You can do the searches much more clearly than you can for the other types of IP. And even that can take a year. So
it's almost like so it seems like the 20-year is the process of when you filed, right? It's not once it's approved, it's, you know, from the moment you filed. So
once the information is out, like once the details of how the product is, yeah.
And how is the pricing determined as to how much, for example, the patent will be? Is it a flat fee, or does it depend on the value of the product?
Yeah, so the person's income and the income of the business itself will be taken into account. But so that's with the patent office. I'm not sure, like it's also the USPTO, the US Patent and Trademark Office. So I'm not sure how much the basic fees are with them, but there is a scale. But the cost for your attorney is going to be crazy. It'll start around $15,000, and it depends on how technical your item is. Also, if it's very parallel and similar to other items, but you know that it's unique and you still want to go forward with it, just the proving part to show that it's different from those other items in existence will take a lot of time and money.
Yeah. So as a small business, it's, thinking about the financial part of it, right? Okay, how much do you have to invest in order to protect this patent, and what's the outcome goals, right?
And using IP by contract, or
IP
you
by
need to use non-disclosures when you're talking to people, confidentiality agreements. So if I'm looking for investors, if I know Mia is looking to spend some money somewhere and I'm like, all right, I have an idea and I want to show it to her, hey, I'm not going to trust her, especially if she's a lawyer, get it in the contract first that she's not going to share that information.
Absolutely. And we have another interesting question here. And the question is, it's in regards to patents. And the question here, if there's already a product out there and I, want to modify that product that currently exists, is that something that can be possible? So I guess that requires a lot of creativity, right, as to how you're going to be modifying that specific product.
Sarah, are you prepared for this question?
I can take a stab at it and you can correct
Mm-hmm.
me. It depends. First of all, it depends, I think, if there's a patent on that product already, or kind of the protections around that product, whether or not you can derive something for it. And then it depends how much it gets modified and whether it's super new and no one has done it, and whether it's obvious or not. So if it's something where like, oh, I modified it, but anyone could have done that with my skill level, and seen right away that that is an obvious modification, that wouldn't count. But I believe later on, like once the IP protections are gone, you can modify products. But please correct me if I'm wrong.
Yeah, and so you could be prepped, waiting to jump on it. There are patent trolls, people who just keep looking at what patents are going to be coming out to see, all right, how can I change it? And let's say this is not something patentable, but just for clarity, I made a burger, and then all of a sudden Sandra's like, well, I know how to make that better. And she comes with a little cheddar cheese and she makes the cheeseburger. So although I have my patent for the burger, it's the question of, okay, was it obvious to add the cheese to it? And Sandra could be like, if it was obvious, Desiree would have done that too. So then there's that little argument going on. But also, even if I'm wrong or right or whatever, I'm stopped from adding cheese to my burgers now because Sandra came with it first. So it's like she could stop my innovation from continuing. So it isn't black and white, but it is not worth it for someone to start inventing on someone else's invention because it's already under protection, and then they cannot exploit the invention. I mean, potentially Sandra could be like, hey, Desiree, I made this up and I know, you're looking to waste some money out here, and you could just give me, she's going to license it out to me.
Thank you. Thank you for clarifying that patent question. And we have another question here, not so much on patents, but this is just on protecting ideas. So the question is, how do people get their ideas protected if they are not a tech designer who needs to develop it? So I think it goes back to that IP contract, right?
Mm-hmm. Through like protecting the idea, like if you have to share information, like let's say, Sarah, Sandra, and I are going to start a business together and we want to recruit Mia. So we want to let her know, hey, this is what we're working on. This is our secret sauce and everything. Yes, to protect ourselves is the confidentiality that matters, and to do a non-disclosure agreement before we share any private information. And otherwise.
Yeah, and there's a question that here at the organization we get asked at, throughout the year here, and so the question is, let's say for example, there's a small business that's really successful in regards to their local customers, and now they're starting to branch off into other markets, and they want to create merchandise for the business, and so they want to protect. What is it exactly that they should be protecting? Is it the brand of, like, if, for example, if they have a logo and they want to create merchandise for the business, like t-shirts or baseball caps, is it the logo that they should be protecting, or is it the name of the business? I know it's a very vague question, but it's just one of those questions where, I want to create merchandise from my logo and put it on different merchandise products. What should that process look like?
So for the best protection, obviously you want to do copyright protection for the images that you're using, but also trademark protection for your brand, because you're growing both at the same time. If you're tight on money and you're trying to figure out which one should I do instead of the other, you got to think about which one is the one that's going to propel you forward the most. You know that if something is about imagery, you're going to have that copyright protection already kind of in your pocket once you start using it. Depending on how distinct your trademark is, it matters like how much protection you're getting there. Like, but if you're using it locally, like if I'm in Fresno and I have this really cool brand, and it's really unique and no one's using it, but then somebody gets word of my brand and they go and get a federal trademark protection over it, I'm still allowed to use it, but only in Fresno, and they could use it everywhere else. So that trademark really does matter. Copyright, if you want to sue somebody for using your image or words or any creation that you've already created, remember, because you can't just have the idea, it has to be created, fixed in a tangible form. If you want to sue somebody, you just file, like you could file today with the Copyright Office and then just file your lawsuit. But if you file already for your copyright, you get statutory damages alongside, because the person is already supposed to be on notice that you have the copyright for this. So you get extra money. Let's say I am doing a series of workshops online. If I'm doing one printout, it could just be the $45 for an electronic filing for my copyright. If I have a series of things, it could be like $75. And then if somebody sues me, then I get, more in the thousands back versus just getting exactly the money that I've spent on it. It's a lowered bar. But okay, to answer your question, both things you want to worry about. Yeah. But when you have, let's say you don't have a trademark and you want to get your stuff out there, if you just start using it locally, you get that geographic scope. My poor version of trying to get more protection is by selling things on Etsy, throw it on eBay, all of those other different platforms, because once you start getting buyers from all these different geographic locations and pings from different states visiting your website, you can make the argument that, hey, your geographic scope extends to those areas. And then if somebody wants to go steal your trademark, they're not really going to want to, because they can't be selling it in those areas.
Absolutely. And I know that the contact information for New Business Community Law Clinic team is on the screen. And in the chat, I'm going to share a specific link. That way, for those participants that are joining us in the Zoom call, if you want to schedule a one-on-one consultation just to go over your ideas, I know the team is available. So I'll be sharing that link here on the chat box.
And I see questions about patents. So we do not do patent work ourselves, but we can try to look for attorneys to refer you to, because of the nature and extent that patent goes into. It's not something that our clinic does.
Okay. Thank you for clarifying. Also, of course, previous presentations that we, co-hosted has been topics on, if you're looking to hire workers, what does that process look like? Expanding outside of family business or family employees, as well as any questions regarding small business, getting started, legal entity. I know that's a big one. There's a lot of questions, so you can reach out to the Berkeley Law team. And
okay,
there's
one last question here, because I gotten it privately as well.
Oh, okay.
Copyright does not protect clothing per se. It has to be a big bar in order for it to protect clothing. In Europe, it could be a different story, but since we're in the US, it's mostly like the art, books, music, written stuff. And when it comes to clothing, because they're pieces of art that we wear and are necessary and they're basic, that the US doesn't see fashion as copyrightable per se as of right now. So if you're doing something interesting in that realm, and it's something that's persistent, or for example, you're doing red outsoles in the bottom of your shoes, like Christian Louboutin, then you could get a trademark for that, and then be in court over it over and over again in the US and in Europe. because these things are not black and white. So even when you ask a question and we're like fishing around, it's like we're trying to find the answers with y'all. So it becomes tricky. But yes, if you have t-shirts, you cannot get a copyright on the t-shirt itself, but the images that you're putting on the t-shirt or the style, like that could be copyright. And also any fabrics, like if you're designing fabrics. All right, that's it.
Thank you so
I think
much.
that's all the questions. So
yeah, I think that's it. So we'll stay on the line for any other questions, and for now, I'll continue on here with our. Let me share the screen here. Oops, I think I need to exit. Sorry about that. Technical. Okay, I'm going to just close this presentation. There we go.
And Sandra, I see someone says que es una prenda de vestir especial, una prenda como joyería, like jewelry. Is that what?
And I think it's like a clothing. Yeah, if you can.
Porque si una prenda como joyería, like jewelry, then that's will fall under copyright. Just trying to.
If you can please clarify that question. I'm not sure who answered that question, but I guess the example could be of jewelry, right? So I'm going to just quickly transition here, as our closing remarks here. Once again, thank you so much to the team, to Sarah and Mai and Desiree for today's presentation. So once again, here is their contact information. Please go ahead and follow them on Facebook, follow them on Instagram. And here is their social media handle. And you can also visit the website to check out other content that they have available. As mentioned, this is a wonderful legal resource for the small businesses that are in the startup phase of their business, or perhaps you are just celebrating your 1-year anniversary. This is a great legal resource here offered at this here for our Central Valley businesses. And I want to just quickly remind you of some upcoming webinars that we have here with the foundation. And to register, you just simply visit our website at fresnoahf.org/events. And next Tuesday, we're going to be having a Spanish webinar, and it's going to be focused on corporations and LLCs, and what does it mean? What are my responsibilities as a small business that just filed for a corporation? New law updates, tax responsibilities. So we'll be having 2 presenters, our moderator, Juan Carlos Ruiz Lopez, and our CPA presenter, Elia Sarpando, to answer all of your questions regarding corporations and LLCs. And also next Friday at 10 a.m., we will be having City of Fresno Code Enforcement Manager join us to share with us what are these new COVID-19 guidelines for businesses that have either reopened, plan to reopen, or want to be prepared on how to keep up to date with these constant changing guidelines. So for more information, once again, please visit our website. And here is our contact information for the foundation. So any questions that you have, I do want to remind you that today's presentation is being streamed live through our Facebook account and also being recorded. And so every participant will receive a link to the recording that will be directed to our YouTube account. So thank you so much, everyone that joined us for today. I hope you have a wonderful weekend and take care. We'll see you next time.
Thanks so much.